topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk Board TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. This is the first Thursday of the month, so that means Ask the Experts is going to be bringing you I'm going to tell you this. This is our number one show from all of our markets, not just here in South Florida. It's K. Bender Rimbaum, their community association law firm, one of the finest in the state of Florida. They also do a show with us in Tampa and Orlando, but this is our number one show. So that means our expert attorney, Robert, is the number one guy. Good afternoon, Robert.
Good afternoon, Steve. Hello, everybody.
Well, congratulations. We just got the numbers, and your show is by far our number one show, most participated with our audience, and just by the letters we get, people love your show.
Well, we're happy to hear that. Happy to be here with them.
Well, just keep doing. You've been with us for about 10 years now, and it's amazing. Our lines still ring off the hook. Our chat lines keep going. People just, you offer this service. It's a free service to our listeners and viewers, and that's not an easy thing to do when it comes to talking to an attorney. If you'd like to call in, our number here is 561-623-9429. We always go over all of your classes. I've got to remember this time, Robert, to do it closer to the beginning and in the second half of the show because people miss it. And so we'll be doing it twice during the show. Your schedule for the month for your free classes. Tell everybody
it's a busy month, actually.
Oh my gosh, you got a lot going on. Tell people who K. Bender Rimbaum is.
Well, K. Bender Rimbaum is a full-service law firm, but we concentrate and specialize in the area of community association law, condominiums, homeowners associations, cooperatives primarily. Any aspect of the legal needs of a community association, dealing with unpaid assessments, dealing with questions about who's got the right or responsibility to take care of this or that within the community, negotiation of contracts, dealing with cities, amending the documents, anything you can think of that might be a legal issue for community associations is what we do. We do that out of our offices in Pompano Beach, Palm Beach Gardens, Tampa, and Orlando. We also have a meeting facility in Miami by appointment. So we're very much available. You can see lots of good things on our website at kbrlegal.com. And we try to be accessible to all of our association client needs.
Robert, your firm gives out so much educational information, whether it's a show like this or the classes that you offer. It's just so great how good customer service is as well to your firm.
Well, thank you. And while a lot of not so good things came out of COVID. One of the good things that did is the extensive use of the Zoom format. So we're able to provide our classes on a Zoom platform. And that way we're able to reach a lot more people and make it a lot more accessible rather than everybody coming into our various locations or doing our traveling show. We've done that on an annual basis, although since COVID, we haven't been doing that quite so much.
Well, I tell you what, now is probably the best time because we know our lines are going to get busy, and so is the chat line. Why don't we start off with all the classes you've got coming up? And may I say free classes you've got coming up the month of March?
All right, then. Starting next Friday, March 15th, 12 noon to 1 p.m., CAI FLA Legislative Update will be presenting via Zoom Lisa McGill from our Pompano office. It's hosted by CAI Florida Legislative Alliance. That's going to be changes to the law that went into effect or will be going into effect, things that are being considered and adopted at the current legislative session. Then on Tuesday, March 19th, Miami-Dade Happy Hour with the CEU. The CAM University is putting on a function down at Ruth's Chris in Coral Gables from 4 p.m. to 6 p.m. Michael Bender will be present to discuss or meet with people for various things. Then the screening process, develop procedures and train your committees on Wednesday, March 20th, 12 p.m. to 1 p.m. on Zoom. Allison Hertz from our Palm Beach Gardens office. There is one CEU of credit for managers hosted by Community Association Institute Gold Coast chapter. Then on Wednesday, March 20th, again at 5:30 to 7:30 p.m., we have a Homeowner Association Board Member Certification class, which will be taught by Danielle Brennan, also of our Palm Beach Gardens office. There are two CEUs in this particular presentation. It's hosted by Campbell Property Management. And on Tuesday, March 26th at 7:30 in the morning until 9 a.m. at Galuppi's in Pompano Beach, Breakfast and Education in Pompano, hosted by ACE and TSK Networking Group. Lisa McGill from our Pompano office will be present at that. And then on Tuesday, March 26th, 2 p.m. to 3:10 p.m., that's a little odd, but a little longer. Community Association Collections. Should I pay or should I go? Alan Schwartzide of our Orlando office will be providing the instruction there. And there's one CEU for CAMS and that one. There's on Wednesday, March 27th in Pembroke Pines, a lunch and learn from 11:30 a.m. until 1 p.m. at Capriccio's restaurant in Pembroke Pines. Michael Bender will be live in person at that particular setting, Capriccio's networking group. And then on Wednesday, again, March 27th, from 12 p.m. until 2 p.m., we have the Condominium Association Board Member Certification. Andrew Black from our Pompano office will be teaching that. It's hosted by Campbell Property Management. And the last one for March will be on Thursday, March 28th. Funding construction projects, loans, assessments, and reserve spending. That's an important one coming up for a lot of condominiums in the near future. 11 a.m. to 12:15 p.m. live via Zoom. Kirsten Hens from our Tampa office will be providing that particular seminar. That's hosted by Synovius Banking. There's one CEU for that. There's also some expos coming up in April. Some will be happening before I see you again. So Monday, April 1st, will be in Tampa. Wednesday, April 3rd, will be in Broward County. Wednesday, April 10th, will be in Palm Beach County. And Orlando has to wait until May 21st. So go to our website, kbrlegal.com, click on the calendar. All the events are listed there. Choose which one you're interested in. And make sure you're registered so you can get the information to participate. And for those in-person ones, make sure that you're counted as coming.
Wow, you have got a busy, busy month. And, I'm sure I know everybody appreciates you offering all these classes. I'm going to just touch on something because we've gotten so many emails, but the governor has not signed any of these, so it's really silly to get started with them right now. But we
But we don't
did
want to
get you.
get too deep in the weeds yet.
Yes. So we will, as soon as these new laws go into effect, if they do go into effect and the governor signs them, we will be bringing them on the show and to discuss them. So I just want you to know we did get your letters, but it's a little premature to really talk about this. I guess the good thing is it sounds like maybe they're going to uh, offer certification for HOA in a little bit stronger way, but we'll just
Well,
have
that
to see.
that may be coming. Certainly, it's changed for condominiums. There is one bill that's passed. It's got a lot of stuff in it. Haven't had a chance to totally digest it yet. Next month in our next show, we should have a much better view of what new laws will be coming our way. They usually take effect in either July 1st, or October 1st. In the bill that I looked at yesterday, it had both effective dates for certain parts of it. So those are things to look forward to in the coming months.
Okay. Well, let's go to, like I said, we always ask you if you've got a question, you can send it in 954-336-3767. Or you can go to our chat line right now, or you can call us at 561-623-9429. We're going to go to Jennifer and Davy. I love your show and your classes. There is not enough handicap parking in our condos. What can I do about this?
There's very little that you can do as an owner, Jennifer. I don't know if you're on the board or not, but generally speaking, when parking is put in place, when the community is developed, that's based upon a site plan that's approved by the local government agency. And to make changes in your parking configuration, you're going to have to submit documentation to the city or the county, depending on where you are, as well as do amendments to your governing documents to provide for these changes. If you're going to be doing a resurfacing of your parking area, that's a time when most local governments require that you bring it up to the current code. So if your handicap parking isn't to code currently, when that occurs, that could be the time when that would be addressed. Handicap parking is often misused in many communities. It's not supposed to be for the residents unless somebody has a specific need and requests a reasonable accommodation under fair housing laws. But generally, handicap parking is guest parking. Not most communities have assigned parking space for the residents, and the handicap parking would be for the guests. Now, if an owner needs a handicap parking spot, typically they'll have to trade in their assigned spot for the handicap spot if a reasonable accommodation is being requested.
Never knew that. We're going to go to our chat line one. Let's leave this up so that Robert can read. It's a
Not sure I
lengthy.
can read it.
Well, please clarify federal judge ruling CTA unconstitutional. HOA attorneys are representing law as currently unconstitutional. HOAs, question mark. If so, what entity might or could that be?
This is a federal law that requires corporations to register certain information with the IRS. And that's supposed to go into effect at the end of this calendar year. It affects all corporations over certain sizes, and HOAs and condominiums have been considered to be included, and lobbying has been going on a federal level to see about getting exemptions for that. There was a district court ruling last week somewhere outside of Florida that held the statute unconstitutional. I haven't seen the actual case holding, but there's been some talk that it was unconstitutional as to the people involved in the lawsuit only, and not a general ruling for the whole country. I've also heard that the party was the SBA, and the SBA represents a large swath of the overall country. So right now, it's not exactly clear if that's ultimately going to be unconstitutional or not. The good news for associations is there isn't an urgency of compliance right now. Toward the middle to the end of this year is when most associations should be looking at that more seriously to see if that's going to be a requirement. It's a bit intrusive for community association board members, and anyone involved in the operation have to provide certain personal information and be registered with the IRS with it. The point of it has nothing to do with associations, and associations are being caught up in the overreaching statutory adoption by the federal government. So more on this as the months go by. That's a good question, though.
Yes, great question. Thank you, Kyrie. Let's go to Joel. Would a board which doesn't endorse liens, delinquent special assessments be in a breach of good faith and thus personally liable?
I think Joel means enforce, not endorse. So if I understand your question, Joel, you're saying your board does not pursue individuals who aren't paying their assessments. If that's the case, that would be a breach of the fiduciary obligation of the board to properly operate the association. The board is required to fund the needs of the association through assessment and to uniformly and vigorously enforce all of the requirements to collect them. The association cannot operate if it doesn't have the funds that it assesses. And if it doesn't have the money, it can't do repairs, it can't maintain the property, and it basically won't function. So if the board is not pursuing unpaid assessments through lien and foreclosure, then they need to take prompt action or be recalled.
Okay, and Joel has a follow-up. If resistors take over the board and abrogate contract, my writing is very small here too. Contracts for work done in progress. Would that be valid? And if not, how to correct that?
Well, if there's contracts in place for whatever work is needed to be done, if it's in progress, I mean, the contracts are valid and in place. If a new board comes in and tries to basically rescind those contracts or terminate them improperly, that can expose the association to damages in the form of money judgment by the contractors, or possibly construction liens against the property and foreclosure, and extensive exposure to attorney's fees on both sides. So it's probably not a good idea for a new board coming in to take such extreme measures. I would urge that board to have appropriate counsel in place before they do anything to make sure that they're not putting their necks into a noose, as it were.
Okay, let's go to Harley and Tamarack. Does the declaration of condominiums ever expire?
Well, that's also a good question that confuses a lot of people. There is a law in Florida called the Marketable Record Title Act, or we call MRTA, which provides that certain covenants in the public record will automatically expire after 30 years from some fairly complicated calculation based upon the date of conveyance of the individual lots in the community or in the first place. So the one exception to that is for condominiums. There are certain requirements that there be in the deeds of all the property in the community that create the exemption from expiration, and that would be a express identification of the original declaration's recording information, the official records book and page in the public records of the county that the property is located in. So the way condominiums are structured, every unit always is identified as unit blank under the declaration of condominium of the condominium located at or book and page of the county. So just by the way they're structured, condominiums will not expire under the Marketable Record Title Act. For homeowners associations, one of the first things we look at for every new client that comes in is whether or not their documents have expired or are about to expire or when they will expire, so that action can be taken before that. If they expire under the statute, then there is a way for them to be resurrected through a revitalization process, but that's a lengthy, complicated, expensive procedure that requires the approval of more than a majority of the owners. If you catch it before, you can just do a process by the board alone, in which the board just republishes them for another 30 years. So that's a much easier, less expensive way to go.
Looks like on our expert chat line, Kyrie has a follow-up. If CTA does apply for HOAs, would attorneys do the filing with, is it FINCEN? FINCEN?
I think that's going to be up to the individual attorneys. I don't know that it's necessary. It might be more appropriate for the association accountant to be doing that, since it's a requirement to file something with the Internal Revenue Service. But attorneys can certainly assist if that's something the board desires.
We're going to go to our first break. Let's give everybody the phone number for the office that's good for all the different locations.
You can reach us at 800-974-0680, or you can go to the website and click on a contact box, or you can write to us at info@kbrlegal.com.
Great. We're going to go to break. When we come back, we have more K. Bender Rimbaum.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Back. This is the Ask the Expert show I'm your host, Steve O. This is the first Thursday of the month, so it's our K. Bender Rimbaum show, the South Florida office in Pompano. We're going to go back to our chat lines. Is it legal for a condo board president to approach owners with a pre-filled out ballot form for board members and ask them to sign the envelopes and give him the completed ballot?
The conduct described here is not something that the statute precludes. It doesn't allow the board president to fill out the ballots, put them in the envelopes, and sign the people's names, but it does allow anybody, a board president, anyone on the board, anyone in the community, to solicit the votes of the various unit owners, so long as it's the unit owner that takes the actual action of putting the ballot in the envelopes and then signing the outer envelope. It's okay to give it to someone else to deliver on your behalf. It's not the best idea for people to be doing, but it's not the purpose of the statute to allow others to cast your vote for you. But that's on the edge.
Okay, we just got a text in. Someone wants to know, is it true no more than 15% of the units can be rentals?
Well, the only time that would be true is if the governing documents for the community provides that. There are concerns when the levels of leased units exceed a certain percentage that can affect the insurability of the community. It affects the ability of securing financing for the individual units under Fannie Mae guidelines and Freddie Mac and FHA. So it's a situation that associations can take action by amending their governing documents to provide limitations on the number of properties that can be leased at any given time. And many of our association clients have done that. The statutes do provide for certain restrictions on associations doing that. In the condominium arena, since about 2005-ish, there's a provision that indicates if you are making it more restrictive on leasing than what is currently in the documents, it's only going to apply to those owners who approve of the amendment and anyone who takes title after the amendment is adopted. It's an open question as to whether that applies to all condominiums or just those that have the so-called Kaufman language or incorporation of these statutory changes automatically into their documents, which is a complicated issue that we try and keep as simple as possible for purposes of shows like this. The same in the HOA setting, but that's a much more recent statute, and most communities of the HOA type that were created prior to, say, within the last 10 years, generally don't have the Kaufman language in their documents unless the boards have put them in by amendment. So it's an open question as to whether that even applies to the existing HOAs.
Going back to the chat lines, the board of directors 720 has two criteria: owing money, felony. Our CAM requires full background check to run extremely sensitive, full credit history, employee history. Is this legal?
Yes, it is legal to do a screening of board candidates to make sure they qualify. But if it's going to be more intrusive than into a criminal background, that might be going a little beyond what is an entitlement for an association to do. When a community has the approval to review and approve pending sales of property within the community, a background check of a fairly intrusive manner is legal and quite often undertaken, which includes residential history, It includes financial information, often looking at tax returns and things of that nature. So the criminal background check is about as far as we suggest it goes. If it goes a little further, that's something that can be resisted, but it could create some problems. You might have to take legal action on that, which can be costly.
Okay, let's go to Kelly on our chat line. Is a board membership or the architectural committee vote to change the guidelines as to paint colors of homes, add types of fences, etc.? Nothing is in the docs stating type, color, or location.
So if I'm understanding the question, they're asking if the board can on its own create these specifications for architectural standards that aren't set forth in the governing documents.
Well, yes.
The general answer to that is that in order for the board to adopt standards, it has to satisfy a basic 3-level test. The first level is that the board has to have the authority to adopt the standards in the first place. So you'd have to look at the documents to see whether there is that type of general policy-making authority identified for either the board or an architectural review committee, so that issue can be determined. The second is whether or not the policies adopted by the board are in conflict with the governing documents. And so you would compare it to the empowering language and whether or not these specifications are included there. And then lastly, whether or not it's reasonable, either on its face or in its application. So typically there is going to be, if there's architectural control standards at all in the governing documents, there would be some indication of authorization in either a committee or the board to create these specifications if they're not specifically set forth. The HOA statute also indicates that the board should be adopting these policies and procedures. So if the empowerment to review and approve architectural changes exists in the documents, in all likelihood, the board does have the authority to adopt that. But this one would require a more involved review of the governing documents to give a complete answer.
And Kelly's follow-up is, do the minutes have to reflect any changes in the architectural guidelines?
Well, when the board takes action, that action should be reflected in the minutes. And that's how a board generally keeps track of the things it does. And if there's ever a legal challenge, that's part of the evidence that's going to be used in either defending the board or the association as to the actions taken by the board. So I would say that there should be either minutes or written resolutions signed by 100% of the board that identifies the actions taken in the association official records.
Okay. Gary in Pompano wants to know, our board of directors blew the budget. They didn't factor in increases in costs. Now they have increased the monthly fees, but stated they are retroactive to the part of the year. Can they do that?
Legally, they can. It's not necessarily the happiest news for owners to get. We're only in March, so retroactive to January isn't that far. What the alternatives are for the board is either revise the budget for the balance of the year to make up whatever needs you have, adopt a special assessment for whatever needs you have, or make it retroactive so that you still owe a little bit for the prior months that have occurred, and then you don't have as big of an increase in the rest of the year monthly payments or quarterly, whichever it is. But yes, it is legal. And in fact, one of the responsibilities of the board is to make sure that all of the financial needs of the association are covered through its assessment powers.
Okay, we're going to go to Kathy, also in Pompano. If a board member resigns, does the open seat have to be filled by a member that ran for the board but did not get elected?
No, the open seat will be filled by whoever the remaining board members want to put in the seat. It doesn't matter who ran before. There may be a limitation as to whether it can be the spouse of an existing board member, depending on the nature of the community and whether there are other available candidates to serve. But they're not required to go to prior candidates for election who did not win.
This is from Stone in Coral Springs, and that is his name, not his position. What authority does an HOA board have to tow cars parked in common area, street, private road, in parentheses? Do they need to post a 24-hour notice on the car or just notice at front of the HOA?
Well, there is an express statute in Florida that deals with the involuntary removal of a vehicle from private property, which is what we're talking about here. If the vehicle is in violation of the covenants, then the board will have the authority to have it removed by towing. In order to comply with the statute, which is section 715.07 of Florida statutes, there's a couple of options. One is to engage with a towing company that is located a specific distance from the community, depending on the population size of your community, and that there be signage that is put in the community that identifies the towing company and a number that they can be reached 24 hours. And that depending on how the community is laid out, where those signs have to be. If it's an enclosed community with limited entrances, then the signs typically are just at the entrances. If there's multiple ways in and out and it's more open, then the signs have to be located certain distances around the community. But the towing companies generally have sufficient knowledge of the statutory requirements to put the signs in the right places. The other alternative, if you don't go that route, is you have to give actual notice to the vehicle owner, either with a notice on the car itself, or if you know how to reach them. The first option is what most communities do, and it is the better approach from the association perspective. It does provide the sufficient legal protection from challenge. If there's a wrongful towing under the statute, the owner's entitled to damages incurred plus attorney's fees. So the attorney's fees can far exceed the cost of storage of a vehicle for a couple of days. So you don't want to be in that situation if you can avoid it. So the vehicle has to be in violation of something. You can tow it from the lot itself. You can tow it from the common area streets. Anywhere within the community that the vehicle sits that's in violation of the covenants is available for towing if necessary.
Well, I had promised everybody towards the beginning of the show that we would talk about the different classes and courses you offer during the month, and let's do it again if you don't mind.
No, let's do it. Starting Friday, March 15th, the CAI FLA's legislative update at 12 noon to 1 p.m. Lisa McGill will be presenting. It's hosted by CAI Florida Legislative Alliance. It's an information event. There's no continuing education credits, but it covers legislation that's going on in the current session. On Tuesday, March 19th, from 4 p.m. to 6 p.m., at the Ruth's, Chris, and Coral Gables. There's a Miami-Dade happy hour with CEU hosted by Cam University. Michael Bender will be present. There will be a presentation on mold mystery myth remediation method. I don't think I mentioned that before. Then we have on March the 20th, we have 2 items. At noon from 1 p.m., we have the screening process, develop procedures and train your committee. Allison Hertz from our Palm Beach office will be presenting that. There's 1 credit for that, and that's hosted by Community Association Institute Gold Coast chapter. The second on March 20th at 5:30 to 7:30 p.m., Homeowner Association Board Member Certification presented by Danielle Brennan out of the Palm Beach Gardens office. 2 continuing education credits are available there. Campbell Property Management will be the host. On Tuesday, March 26th at 7:30 a.m. to 9 a.m. at Galuppi's in Pompano, breakfast and education in Pompano, understanding elevators, ups and downs of safety maintenance. Lisa McGill will be on hand to participate in that event. She's out of our Pompano office. Then on Tuesday, March 26th, a second item at 2 p.m. to 3:10, Community Association Collection, Should I Pay or Should I Go? That will be presented by Alan Schwartzide of our Orlando office. Then on Wednesday, March 27th, a lunch and learn in Pembroke Pines, 11:30 a.m. to 1 p.m. at Capriccio's restaurant in Pembroke Pines. Michael Bender will be there. They'll be talking about association loans, what CAMs need to know. Association loans is a big topic these days, given all of the work that's going to be done under the new laws for condominiums. And then on Wednesday, March 27th, a second item at 12 noon to 2 p.m., Community Association Board Member Certification will be presented by Andrew Black out of our Pompano Beach office. Then on, Thursday, March 28th, the funding construction projects, loans, assessments, and reserve spending. That's an important topic coming up at 11 a.m. to 12:15 p.m. Kirsten Hens from our Tampa office will present. There's 1 credit for continuing education there. And there are expos happening in April, 2 of which will happen before our next show on April the 1st in Tampa and on April the 3rd in Broward County. Palm Beach County will be April the 10th and Orlando will be May 22nd. We have 2 educational seminars in both. More information on that is available on our website at kbrlegal.com. Click on the calendar and then choose the event you're interested in to register and get your Zoom information or register for the live in-person attendance.
Okay. Busy month.
Yes, indeed.
Let's go to the chat line again. And I know we've only got about 5 minutes left.
Let's get in as much as we can.
Yeah, there's a lot of people on her chat line, but let me go to Roger. Can a current HOA board of director change the minutes from a vote 19 months ago of a previous board of director? A board member says that he abstained from a vote. However, minutes 19 months ago affirm his vote as present.
Well, minutes can be changed even 19 months after the fact if people with personal knowledge are there and the board agrees to do so. It's not a legal problem if that's the case, and it's making them more accurate. If it's to make it, the change that's addressed here from abstain to present doesn't really have a substantive difference in the results that the meetings reflect, because saying present doesn't constitute a vote any more than abstention does in this setting. So it's not really a legal problem if they decide to do it, but it's going to be a board decision whether they do or they don't.
Robert, in our few minutes we have left, there are probably board members, management companies that are listening or viewing right now. Tell people why they should retain your firm.
Well, K. Bender Rambam has been providing these services to community associations continuously since 1992. We have, between all of the 20 plus attorneys that work with us, literally over 100 years of combined experience in the area. We have board certifications by the Florida Bar of at least 10 of our attorneys, and I know one's taken the test this week, so our fingers are crossed that he qualifies, but he certainly has the experience and capability. It's just a matter of passing that last part of a test. The board certification is done by the Florida Bar, and it requires that there be a certain level of experience. There's peer review requirements, and there's test requirement, and then ongoing continuing education requirements to maintain the status. It's a higher level of capability in the field of specialty. And it does allow you, under the rules of the bar, to say you're a specialist as opposed to someone who may concentrate on the area. And so we have that. We are service oriented in that it's always been our mission to provide a prompt, efficient, cost-effective legal advice to our clients in a manner that's understandable to the layperson. We don't write legal treatises or things that you require to hire another lawyer to translate the information we provide to you. We return our calls the day we get them, and we respond to emails as promptly as we can under the circumstances. We know that when you come to your lawyer, you don't do it just for fun. You're doing it because you need something, and your needs are important to you, and they need to be addressed in a timely fashion, which is what we require of all of our attorneys. So hopefully that gives a good overview.
Yes. Well, I got to tell you, by the response this show gets, we are so blessed to have your firm, as our expert in community association law. The name of the firm is K. Bender Rambam. Let's give everybody your phone number and website.
Reach us at 800-974-0680. Website is kbrlegal.com. You can write us at info@kbrlegal.com, or go to the website. There's a contact box on the first page. You can fill that out. Someone will get back to you.
Well, this show always goes by so fast, Robert. Hey, and we wish you well. I know you've had eye surgery, and we're just so glad we've got you. And you'll be back with us again next month, first Thursday of the month.
Looking forward to it.
And that'll be it for you today. Thank you for allowing us on your radio or TV podcast. We'll be back with you again next week with more Ask the Experts.
Bye, everyone.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk 4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.